E1 and E2 visas serve as critical tools for international business and commerce, allowing nationals from treaty countries to enter the U.S. The E1 visa is designed for individuals engaged in substantial international trade, whereas the E2 visa caters to investors overseeing operations in the U.S. These visas are non-immigrant by nature, meaning they don't directly lead to permanent residency. The eligibility for these visas requires a treaty of commerce and navigation between the applicant's country, and the U.S. applicants must also demonstrate a substantial flow of trade for E1 or a substantial investment in a U.S. business for E2. These classifications are typically granted for 2 years, but can be renewed indefinitely as long as visa conditions are met. Despite their non-immigrant intent, many E1 and E2 visa holders develop a deep connection to the U.S. and seek ways to obtain a green card. The transition from an E-visa to permanent residency, however, involves navigating complex legal pathways, which we will explore in the following sections. Understanding these visas is the first step in planning a long-term stay in the U.S. It's crucial for visa holders to know their options and prepare accordingly, as each pathway to a green card involves distinct requirements and processes. One prominent route for E1 and E2 visa holders, especially those in managerial or executive positions, is through the EB1 visa category. This category is reserved for individuals who demonstrate extraordinary ability in their field, outstanding professors or researchers, and multinational managers or executives who have been employed by a company for at least 1 year in the 3 years preceding the application. For multinational managers or executives, the key requirement is that they must have been working outside the U.S. in a managerial or executive capacity for the same employer, an affiliate, or a subsidiary. The U.S. employer must have been doing business for at least 1 year and must intend to employ the applicant in a managerial or executive capacity. The EB1 route is particularly attractive due to its preference in the green card queue, often resulting in shorter waiting times compared to other employment-based green card categories. Applicants do not need a labor certification, which simplifies the process significantly. However, the standards for EB1 approval are high, and the applicant must provide substantial documentation to prove their eligibility. This includes evidence of employment history, the nature of the managerial or executive role, and the company's operations both domestically and internationally. Spouses of E1 and E2 visa holders also have potential pathways to permanent residency, though these routes are not automatic and require careful planning and legal compliance. Initially, spouses are granted an E1 or E2 dependent visa, which allows them to live in the U.S. but not to work or seek permanent residency directly. One potential pathway is through employment. If the spouse finds qualifying employment, they may be able to change their status to a work-based visa category that provides a clearer path to a green card, such as H-1B or L-1 visas. These visas have their own requirements and processes, but can eventually lead to permanent residency through employment-based categories. Additionally, if the principal visa holder transitions to a green card via an EB1 or another eligible category, the spouse can apply for a green card as a derivative beneficiary. This means their application is dependent on the approval and status of the principal applicant's green card process. It's important for spouses to maintain legal status throughout their stay and seek legal counsel when considering changing their visa status or applying for a green card. Each case is unique, and the eligibility and requirements can vary based on individual circumstances. Marriage pathways to U.S. citizenship or green card. Marriage to a U.S. citizen or permanent resident offers a significant pathway to a green card for E1 and E2 visa holders. This process begins with the U.S. citizen or green card holder spouse filing a Form I-130, Petition for Alien Relative, on behalf of the visa holder. This form establishes the marital relationship and is the first step in the application process for residency. Once the I-130 is approved, the E1 or E2 visa holder can adjust their status to that of a lawful permanent resident by filing Form I-485, Application to Register Permanent Residence or Adjust Status. This process is generally quicker and less cumbersome than employment-based green card applications, especially when the marriage is well documented and bona fide. However, marriages solely for the purpose of obtaining immigration benefits are scrutinized closely by U.S. Citizenship and Immigration Services, USCIS. Couples may be required to provide extensive proof of their relationship, including financial records, photographs, and other personal documents, to demonstrate the legitimacy of their marriage. Moreover, the visa holder must enter the marriage in good faith, and not solely for the purpose of immigration benefits. USCIS conducts interviews and investigations to ensure the authenticity of the marital relationship, which can include visits to the couple's home and interviews with friends and relatives. Exploring the diversity visa program and EB-5 investment. Besides employment and marriage, other options such as the diversity visa program and the EB-5 investor visa offer alternative routes to U.S. permanent residency. The diversity visa program, also known as the Green Card Lottery, provides up to 50,000 green cards annually to individuals from countries with low rates of immigration to the U.S. Eligibility is based on nationality and meeting simple but strict education and work experience requirements. The EB-5 investor visa is another significant option, designed for individuals who can invest between $900,000 and $1.8 million in a U.S. business that will create or preserve at least 10 full-time jobs for U.S. workers. This program not only facilitates U.S. residency, but also contributes to the U.S. economy, making it a win-win scenario for both the investor and the local community. Applicants for the EB-5 visa must demonstrate that the investment funds were obtained through lawful means and that the investment meets all the necessary criteria. The process involves filing a Form Y-526, Immigrant Petition by Alien Investor, and upon approval, either adjusting status in the U.S. or processing the visa through a U.S. consulate abroad. Both the diversity visa and the EB-5 programs are subject to changes in U.S. immigration policy, so potential applicants should stay informed about the latest regulations and quotas. These programs are not suitable for everyone, and the choice to participate should be made based on thorough understanding and professional advice. Conclusion: the value of expert legal guidance. Navigating the complex landscape of U.S. immigration law is challenging, especially for E-1 and E-2 visa holders aspiring to transition to permanent residency. Each available pathway, whether through employment, marriage, investment, or the lottery, requires meticulous planning, adherence to legal requirements, and timely application. Consulting with an immigration attorney can provide invaluable assistance. Legal experts can offer personalized advice tailored to individual circumstances, help navigate the bureaucratic complexities, and increase the likelihood of a successful application. They can also provide updates on the latest changes in immigration laws and policies, which can significantly impact application strategies. Ultimately, while the journey to U.S. permanent residency can seem daunting, the right guidance can make it manageable and successful. E-1 and E-2 visa holders should consider all their options, plan strategically, and utilize professional resources to achieve their American dream. In conclusion, whether you are a multinational executive, a spouse, or an investor, understanding your legal pathways and options is crucial. With the right approach and expert advice, the dream of U.S. permanent residency is within reach.